Welcome and thank you for standing by. At this time, all participants are in listen-only mode. During the question and answer session, to ask a question, please press star and then 1. This call is being recorded. If you have any objections, you may disconnect at this point. I'll now turn the meeting over to your host, Ms. Bessie Chan. Ma'am, you may begin.
Hi, everyone. Good morning, and thank you for joining our Region 3 Interagency Working Group webinar on workplace and workers' rights. Just as a reminder for those of you on the conference line today, please be sure to also log on to the WebEx portion of the webinar in order to view the presentation that accompanies today's webinar. The link was included in the confirmation email that you received. So the mission of the White House Initiative on Asian Americans and Pacific Islanders is to improve the quality of life and opportunities for Asian Americans and Pacific Islanders. As part of this mission, we are working with a regional interagency working group, an entity comprised of more than 220 members from federal agencies and sub-agencies across the country to bring you in-person and online events and trainings to raise awareness of and promote participation in federal programs, resources, and services where our community is underserved. Today's webinar is hosted in collaboration with the U.S. Department of Labor Occupational Safety and Health Administration, the U.S. Department of Labor Wage and Hour Division, and the U.S. Equal Employment Opportunity Commission. First, we will hear from Ms. Isabel de Oliveira, Philadelphia Regional Office's Compliance Assistant Specialist on OSHA's efforts to ensure safe and healthy workplaces, information on employee rights, and employee resources and compliance. Isabel?
Thank you. Hello and welcome, and thank you for taking the time to briefly learn more about workers' rights and compliance under the OSHA Act. The Occupational Safety and Health Act covers most private sector employers and their workers, federal workplaces, and their workers in the 50 states and certain territories and jurisdictions. In the last 4 decades, OSHA and our state partners, with the efforts of many, many employers, safety and health professionals, unions, and advocates, we've had a dramatic effect on workplace safety and health. Since 1970, workplace fatalities have been reduced by more than 65%, and occupational injury and illness rates have declined by 67%. And at the same time, U.S. employment has almost doubled. We can be proud that workers' deaths in the United States are down, on average from about 38 workers' deaths a day in 1970 to about 12 a day in 2012. But that really is 12 too many. Workers' injuries and illnesses are down from 10.9 incidents per 100 workers in 1972 to 3.4 incidents per 100 workers in 2012. And what this means is that there is still much more work for all of us to do. It has been said that Latino workers often do the most dangerous work with the least amount of protections. But I believe that any vulnerable worker can be exploited if their employer does not provide a safe and healthy workplace and implement an effective safety and health program. Because of language barriers, literacy issues, lack of training, and many other challenges, immigrant workers are often hard to reach and are also at the greatest risk for injury, illness, and death on the job. These vulnerable workers are the least likely to speak up for their rights. And their rights are that all workers in the United States are entitled to a safe and healthy workplace. They are to work in a place free from recognized hazards. With few exceptions, employers must provide the proper personal protective equipment required to do the job and train workers to use it. They have the right to talk to or complain to OSHA without fear of discrimination or retaliation. And all personal employee information is confidential during any complaint intake as well as during inspection interviews. Other OSHA rights that we provide employees is the right to ask OSHA for an inspection receive information and training about their hazards, and get copies of test results done in workplaces. As I said, all training must be provided to employees. All workers must be trained on how to properly perform their work, and it must be provided in a language and a manner in which they understand, whether that be pictures or pictograms, sign language, or a foreign language, such as Mandarin or Tagalog. All workers are to be trained in the proper use of the chemicals in their workplace, how to gather the information from the label, and be, again, provided and trained on proper personal protective equipment. All workplaces must also have a process on how to report any unsafe conditions, whether that be through the temporary staffing agency that placed them or their host employer. Also, some training is required annually, such as bloodborne pathogen training. Also, training is required when a process or a procedure changes, with regard to examples being chemical substitution or when emergency exit routes are blocked by excessive grass growth, snow blockage, or building construction. This is a bit of information on how to contact OSHA from the employee information page. It has information on how to properly file a complaint, how to report any emergency with our emergency number and our contact information being 1-800-321-OSHA or 1-800-321-6742. On these pages, you'll learn more information about our regional and area offices and how their business hours are 8 a.m. to 4:30 p.m. in the local standard time, how we have language and translation services available during business hours if you feel more comfortable calling in a language that is not English, and resources on how to contact a compliance assistant specialist or labor liaison to help navigate the OSHA's organizational structure, internet web pages, further explain the complaint process, and assist them with their safety and health programs. This is a screenshot of our OSHA webpage, osha.gov, and you'll see that accessing our OSHA webpage through mobile devices and tablets has now become a little bit more friendly, so it does not matter if you don't have a laptop or a computer at home or at work. In the top, you'll see that we have recently updated our reporting regulation across the United States. Under 1904.39, each and every workplace-related fatality, including heart attacks, needs to be reported to OSHA within 8 hours. All work-related inpatient hospitalizations, amputations, or losses of an eye must be reported to OSHA within 24 hours. All OSHA regulations apply to employers, but if employees do not believe that their employer is reporting it, they too can make the notification. As I had said earlier, OSHA covers most private sector employers and workers in the United States, the District of Columbia, and our territories. But we do have 22 state plan states, and these, highlighted in blue, are state-run safety and health programs, and they must be at least as effective as the federal OSHA program. If you feel more comfortable, you certainly can reach out to the federal OSHA, or if you are in a state with an OSHA-approved state program, you may be subjected to different or additional requirements and have different resources available to you by contacting that state plan directly. Here is Help for Employers. This is our new Help for Employers page, which is a portal to help employers find relevant information on the OSHA website. Some of the information on this page is, what are my responsibilities as an employer? How do I identify and control safety and health hazards in my business? How do I comply with OSHA rules and regulations? I highly recommend starting with the Quick Start, which is in the lower right corner. It will allow for employers and employees to have a better awareness of what the hazards in their workplace will be and provide especially small and new businesses some of the compliance assistant resources that are available to all workplaces. By following the step-to-step guide, users can see an initial set of OSHA's compliance assistance material that they can use to improve their safety and health program in their workplace. The Compliance Assistant Quick Start for general industry covers factories, warehouses, retail, grocery store, and restaurants, just to be a few examples. We also have a quick start for construction, healthcare, and Hispanic outreach. If employers are asking for more help, they could certainly use the on-site consultation service. In fiscal year 2013, nearly 27,000 site visits were done through the 50-state and most territories consultation program. The service is free and confidential, and it's separate from enforcement and do not result in penalties or citations. Consultants will work with employers to identify workplace hazards, provide advice on compliance, and our standards. Other small business resources can be found on the small business page. Examples are Safety Pays, uses a company's profit margin, its average cost of an injury or illness, and projects the amount of sales the company would need to generate to cover these costs. One of OSHA's most popular downloaded publications is the Small Business Handbook, and this handbook assists employees and small business employers to comply with OSHA's requirements by featuring a lot of self-inspection checklists. This is an example of just some of OSHA's language resources: Mandarin Chinese, Korean, Polish, Vietnamese, and Spanish. And how would an employee make a complaint? In accordance with Chapter 9 of the Field Operations Manual, there are two types of complaints: formal and non-formal. Formal complaints are made by current employees or a representative of that employee, and it must meet all of the requirements, asserting that there is an unsafe working condition exposing employees to a potential physical or health hazard in the workplace, be in writing, submitted on any paper, mailed or faxed, and it could even be written in a foreign language. It must be signed by a current employee or their representative. We ask that it also provide contact information for any follow-up questions that the OSHA area office may have. Formal complaints, typically, it may result in an inspection and on-site of the facility that the complaint is referencing. Non-formal complaints will likely result in an inquiry, a telephone call, and a faxed letter. All electronic complaints submitted via OSHA's public webpage are considered non-formal. And non-formal complaints are complaints that do not meet the requirements of the formal complaint. For confidentiality, OSHA never asks about immigration status or country of origin for employees or employers. But employees can also designate their representative. The representative could be a family member, an authorized bargaining unit, an attorney acting on behalf of that employee, your consulate, your embassy, community-based organizations, or other faith-based organizations such as synagogue or temple, anyone that the employee may designate. Other information that we would ask about the employer would be the address and telephone number of the facility, if it is a structure or a transient work site, like a construction site that will be finished up at the end of the week. Other information that would be very relevant and important to put on the complaint is what work is unsafe? Is it that the ladder is not being provided? Is the ladder not long enough? Is the ladder broken or unstable? Were you not trained on how to properly construct the scaffolding? Was training not in a manner or in a language that was understood? Has there been any accidents with this piece of equipment? Has someone else gotten hurt? Is the condition continuing, or did it happen a year ago? Because unfortunately, we do have a 6-month time limit. So, thank you very much for listening to the OSHA information. 12 people is too many per day. We want to help. We know employers sometimes just need help, so we ask that you contact OSHA at 1-800-321-6742 or visit the OSHA page at osha.gov. Now, we will hear from Jack Rutsky, OSHA's Philadelphia Regional Supervisory Investigator, about the various whistleblower statutes that have been delegated to OSHA, what is considered protected activity in order to be afforded protections of the Act and how to file a complaint.
Thank you, Isabel. My name is Jack Rudsky, and I'm representing OSHA's Whistleblower Protection Program. As Isabel mentioned earlier, employees have a right to raise workplace safety and health concerns, and they should not be retaliated against for doing so. However, raising issues, which we refer to as whistleblowing, at times does result in employer reprisals. Our office exists in order to investigate these allegations of retaliation and to remedy the wrongs when we find that they in fact have occurred. Our goal is to create an environment in workplaces where employees can raise concerns without fear of retribution for doing so. While we work for the Occupational Safety and Health Administration, investigating complaints of workplace safety and health retaliation claims is only one example of the type of whistleblower work that we in fact do. As you will note from this slide, OSHA's Whistleblower Protection Program enforces various whistleblower provisions of more than 20 whistleblower statutes. That number now actually stands at 23. That protects employees who report violations of not only occupational safety and health concerns, but of also of certain public safety issues. Our scope most recently has extended to include protecting employees who raise issues regarding health insurance reform and various financial and securities laws and reforms. Whistleblower rights afforded by these acts include but are not limited to worker participation in safety and health activities, reporting a work-related injury, illness, or fatality, or reporting an actual or reasonably believed violation of the various statutes. The foundation of the Whistleblower Protection Program's work is to enforce the provisions of Section 11C of the Occupational Safety and Health Act. Section 11C is the specific section that affords protections for employees to raise concerns about the health and safety conditions of their workplace and to have those concerns addressed without fear of reprisal. The other 22 acts we cover fall into several broad categories as follows. First, we have several acts that address public transportation safety issues. Those include the Surface Transportation Assistance Act, which protects drivers and other employees at that operate commercial motor vehicles regarding their allegations of safe operation of commercial motor vehicles. We also enforce the whistleblower provisions of the Wendell H. Ford Aviation Investment and Reform Act, which we refer to as Air 21. That protects employees of air carriers. Specifically, think of pilots, flight attendants, or mechanics who raise safety and security issues. We also enforce the Pipeline Safety Improvement Act, the Federal Railroad Safety Act, the National Transit System Security Act, and the International Safe Container Act. The Federal Railroad Safety Act protects employees of railroads who raise safety or security concerns, and it differs from the National Transportation System Security Act, which protects employees of public transportation entities who raise not only public transportation safety issues, but also who raise issues of abuse of federal grants or other public funds appropriated for public transportation transportation. The International Safe Container Act contains employee protection provisions for employees who work with intermodal shipping containers. An example of these types of protections might be a driver who is being forced to work over the hours of service regulations and who raises issue about doing that or refuses to do that, and who in turn is subject to some retaliatory action such as termination. Next, we are responsible for various acts that deal with employees who raise environmental concerns. The purposes of the acts are fairly self-explanatory in the names of the acts. We enforce the Safe Drinking Water Act and the Federal Water Pollution Control Acts. We also enforce the whistleblower provisions of the Toxic Substances Control Act. That act protects employees from reporting violations relating to industrial chemicals produced or imported into the United States. Also on the list are the Solid Waste Disposal Act, the Clean Air Act, and the Comprehensive Environmental Response, Compensation, and Liability Act. CERCLA, as it's known, protects employees who report accidents, spills, or emergency releases of pollutants at Superfund sites. It also protects employees who raise issues regarding the cleanup of uncontrolled or abandoned waste. Lastly on this list, you'll find the Asbestos Hazardous Emergency Response Act, which protects employees who report violations of asbestos in public or nonprofit private elementary and secondary schools. We also have afford protections to employees in the nuclear field. The Energy Reorganization Act protects employees in the nuclear industry who raise concerns about nuclear safety. Specifically, these are employees at nuclear power generation facilities or who work in the medical field working with nuclear products. We also have maritime safety protections under the Seamen's Protection Act, which protects seamen from retaliation for reporting to the Coast Guard or other agencies violations of maritime safety law or regulations. We're also involved in providing protections for whistleblowers in consumer safety issues. This includes the Consumer Product Safety Improvement Act, the Food Safety Modernization Act, and lastly, the Moving Ahead for Progress in the 21st Century Act. The Consumer Product Safety Improvement Act and Food Safety Modernization Acts are fairly self-explanatory. The MAP 21 Act protects employees of motor vehicle manufacturers, parts suppliers, and dealerships who raise issues of motor vehicle defects, noncompliance, or violations of any regulations under the jurisdiction of the National Highway Transportation Safety Administration. We're also involved in the enforcement of whistleblower provisions for several non-safety related acts. These include acts that involve financial integrity, such as the Sarbanes-Oxley Act, the Dodd-Frank Act, and the Consumer Financial Protection Act. The Sarbanes-Oxley Act specifically protects employees of publicly traded companies, their contractors and subcontractors who raise issue of various types of fraud or violations of SEC rules and regulations. The Dodd-Frank Act amended the Sarbanes-Oxley Act to include coverage of employees of nationally recognized statistical rating organizations, as well as their contractors and subcontractors. An example of such companies would be Standard & Poor's, Moody's, and Fitch Group. The Consumer Financial Protection Act provides employees who raise issues related to consumer financial products or services for violations of law subject to the jurisdiction of the Bureau of Consumer Financial Protection. And lastly, we're responsible for enforcing the whistleblower provisions of the Affordable Care Act, or better known as Obamacare. The whistleblower provisions under the Affordable Care Act that we enforce protects employees from retaliation for reporting violations of Title I of the Act regarding an individual's receipt of health insurance subsidies, the denial of coverage based on pre-existing conditions, or an insurer's failure to rebate a portion of an excess premium. Now for some of the details about the process of whistleblower investigations work. Each act has unique coverage details, filing periods which range from 30 to 180 days, various burdens of proof, appeal rights, and other nuances. We encourage you to visit the website to learn more about the details of each of these. I would like to point out that regarding the filing periods for each of these acts, the statute of limitations starts when the employee becomes aware that they are going to be subject to an adverse action. For example, if an employee receives a notice of termination to occur in 2 weeks, The filing period, or the clock starting, actually starts on the date that the notice is received, not the date that the termination becomes effective. This is particularly important for those acts which have the relatively short filing period of 30 days, such as the Occupational Safety and Health Act. What is protected activity? This list that you're seeing now is not all-inclusive, but it involves activities such as making complaints to government agencies, such as filing complaints with OSHA, the Environmental Protection Agency, or its state equivalents, various health departments, the Federal Aviation Administration, or the Department of Transportation, the Nuclear Regulatory Commission, or the Securities and Exchange Commission. Also included are cooperating with government investigations. Also, making complaints directly to employers is protected under the various acts. And lastly, testifying before Congress is also considered a protected activity. What are the types of actions that may prompt an employee to file a whistleblower complaint? Most of the acts read that the employer may not discharge or otherwise discriminate against an employee for engaging in protected activity. These are just some of the examples that are considered to be adverse actions. I'd like to point out that a recent Supreme Court decision has changed the way that we look at these adverse actions to include any act that would discourage a like-situated employee from raising these concerns to their employer. If OSHA investigates and evidence establishes that the employee was in fact retaliated against, the agency can order remedies to include these types of remedies: reinstatement, back pay, sanitizing personnel records. By sanitizing personnel records, we mean removing adverse actions from the file so that may not follow the employee when they go to other employers. Postings, other compensatory damages, and punitive damages in only certain circumstances under certain acts. Also, several of the acts allow for reasonable attorney's fees in certain circumstances. How can an employee file complaints? We accept complaints in any form. Complaints can be filed by telephone at the 1-800-321-OSHA number that Isabel had mentioned earlier, or by calling any OSHA area or regional office. Complaints can also be made in person at any OSHA area or regional office. We also accept mail and fax or emails at any OSHA area or regional office. And we also have the online whistleblower complaint form that a complaint can actually be filed online at the site that's indicated in this slide. We invite you to contact anyone in the Whistleblower Protection Program with any questions that you may have. Thank you. Now we will hear from Mr. James Kane, Philadelphia District Director for the Wage and Hour Division, who will speak about the labor laws that Wage and Hour Division enforces, how to file a complaint with the Wage and Hour Division, and what information will be helpful or should be available when filing a complaint.
Thank you, Jack. Good morning, everybody. The Wage and Hour Division has the enforcement authority for several different acts, and we cover most of the workers, not quite all, but most of the workers in the U.S. As you can see, over 7 million businesses and over 135 million workers. Employees are entitled to the protection of the laws, regardless of their immigration status. When we receive a complaint or if we're doing an investigation, we don't actually even inquire about somebody's status, and it makes no difference to us when we enforce the law or when we compute back wages or other remedies under the particular act that we're enforcing. We are located throughout the U.S. And Puerto Rico. One of the things that we like to point out is our language capability in the Wage and Hour Division. As you can see, the majority of our investigators speak a language in addition to English. As a matter of fact, here in my district office in Philadelphia, we're able to speak a total of 9 different languages. In addition, to each individual that's able to do that, we use investigators, lend them to other offices when needed, for their language ability. We also have a language line that we're able to utilize to cover just about any other language that we're not able to handle, through an investigator. And again, as you can see, the predominant second language that we have is Spanish. As I said, we enforce a number of different laws. The most common ones are listed here. The Fair Labor Standards Act, which is the federal law, deals with minimum wage, overtime, and child labor standards. The Family Medical Leave Act, which allows people to take time off for their own medical needs or the medical needs of an immediate family member. The Davis-Bacon-related acts, which is government contracts for construction. The Service Contract Act, which is government contracts for services to the federal government. Employee Polygraph Protection Act, Wage Garnishment Law, and temporary worker programs. In addition to this, one that isn't listed here that we actually spend a lot of time doing as well is the Migrant and Seasonal Worker Protection Act. Ways in which our laws are able to help individuals. As I said, the Fair Labor Standards Act covers the minimum wages and overtime, the sets of standards for child labor. Child labor under federal laws, basically what we're talking about is individuals under the age of 18. The Family Medical Leave Act, again, allows job protections for people taking time off for the birth of a child or caring for sick family members or for their own serious health condition. The Migrant and Seasonal Worker Protection Act allows such standards for farm workers regarding housing, transportation, and wages as well. The next one talked about is for the government contracts, the Davis-Bacon and Service Contract Acts that sets prevailing wages for workers and also requires fringe benefit payments as necessary. And then the last one, again, was standards for hiring and paying workers temporarily in the U.S. There's a number of different visas that we enforce the wage portions of. So workers that are here on H-1B, H-2A, H-2B, and some others, they're protected. They have certain protections regarding their wages and their working conditions, and that's enforced by us. How do we actually go about achieving compliance with the employers? We spend most of our time actually doing enforcement activities, doing investigations. There are two different types of investigations that we do. We do what we call directed investigations or investigations based on complaints. Directed investigations, and I'll get into it in a little bit as well, that's where we pick out places ourselves. It's not based on a complaint, but it's typically based on a particular industry or geographical location where we go out and we do the investigations. We also achieve compliance through outreach. That's both, we'll do presentations to workers and employers. We do compliance through partnerships. One of the things when I was looking through this morning that I thought was kind of an interesting note to show how well partnerships work is that we have partnerships with several of the consulates that service the Philadelphia area. And last week we had a worker who was due back wages who came to our office to pick up the back wage check, but unfortunately he didn't have a form of ID with him, and that's obviously something that we would require just to make sure that the money is actually getting dispersed to the correct individual. But what we worked out was that he was able to actually go to the Mexican consulate to work out with them to be able to get a form of ID to come back and get his back wage check. And then also the use of media to achieve compliance. There are times that we do certain case activities, either if it was part of a directed program or a significant case, we'll often do a press release to get the information out, to increase compliance in an industry rather than just with a particular employer. As I said, we do have a directed program. Directed programs vary, from district office to district office. There are 3 different levels where we do directed programs. Sometimes the national office will do a program throughout the nation and pick out particular district offices to participate. There are also regional and local initiatives. And this, again, is where we want to, pick out places that we know that we find issues with. For example, here in Philadelphia, we have a local initiative dealing with temporary help companies. And that's because what we have found over the last several years is a high violation rate in that industry where they typically employ workers, and not only do they not pay them overtime, but they also often pay them rates under the minimum wage. And we found that to be such a substantial problem, we wanted to dedicate a fair amount of our resources to impact that industry and get it cleaned up. The directed programs are, typically are directed to places where we have vulnerable workers. What are vulnerable workers? Basically, it's people that are in positions where it's difficult for them to, make a complaint against the employer, whether it's, even with us or just even directly saying something to the employer, typically for fear of a reprisal, such as job loss. Here's a list of a number of industries where we typically find vulnerable workers. I would certainly add temporary help industry to this list as well as these. So moving on to complaints. Where do complaints come from? They actually come from a number of different sources. The most common of which is actually employees. We accept complaints from both current and former employees. For the most cases. Like I said, we enforce a number of different laws, so we can have a little bit of variation from law to law, but typically we do accept complaints from both former and present employees. It can be from third parties, such as a parent or guardian. Usually what we're talking about there is, like a child labor violation. From school officials, again, that often deals with child labor violations. Other employers, we don't get a lot, and we certainly screen to make sure that's not something where somebody's just trying to cause trouble with somebody else. But we do accept complaints from other employers. Certainly from advocacy groups, typically what we'll get is somebody who goes to that group for help, and that group is aware of the Wage and Hour Division, what we're able to do. So they'll refer the individual to us to be able to help them out, and certainly other agencies as well. So how are complaints accepted? We accept complaints really in any form. Here it says that they're submitted by person or by phone, but we do also accept a written complaint. If something was emailed to us or mailed to us, we certainly take that information and accept the complaint that way as well. One thing that we like to point out is that when we deal with complaints, again, for the vast majority of the laws that we enforce, the complaints are kept confidential. That means that when we go out and we do an investigation based on a complaint, and not only do we not tell the employer, who made a complaint, we won't even say that we're there based on a complaint, because as I stated earlier, there are different reasons why we do investigations, with our directed programs. So we won't even say that we're actually there because of a complaint. It is, as it says, there's no fee to file a complaint. Just submit the information to us, and we'll work on it. So what is needed during the complaint intake is the employee's name, their contact information, and then information about the employer. We do accept anonymous complaints. We'll do our best to try to get the person, to give us their name and contact information, again, by, assuring them about our confidentiality. But it's particularly important to be able to follow up a lot of times with the complainant. And be able to keep them updated of our progress in conducting an investigation. But as I said, if it really comes down to it, we will accept an anonymous complaint. Other information that's taken, during the complaint process is the type of work that the employee does, the circumstances that surround the alleged violation. And then the last thing that's listed there is copies of pay stubs or personal hours if available. Certainly it's not required, as part of the complaint that they submit this. But again, it helps us in actually going through and reviewing a complaint to help make a determination whether or not, there's a high likelihood of a violation. quickly go through the investigation process for wage and hour, typically what we do is we'll go in, we hold an initial conference with the employer, explain the law that what we're enforcing, and again talk about the process of the investigation with them, tour the establishment so we have a good understanding of how the business operates. The next phase is fact-finding. That's where they interview employees and go through and review typically the time and payroll records for the company. When we do employee interviews, we do keep the interview information confidential. While the employer may be aware, that we're interviewing a specific employee, if we're doing it there at the establishment, we don't release anything that can be traced back to that individual as to what they said. And we also do interviews off-site as well. After all of the fact-finding is completed, we make a determination of whether or not there were any violations. If there were violations, we'll determine what are the remedies. Typically, what we're talking about there is back wages, such as with the Fair Labor Standards Act. If we found, minimum wage or overtime violation, would actually compute the back wages. And typically, we go back for a period of 2 years. Once all that determination made, then we sit down with the employer and we have a final conference, explain to them the violations that we found. We first get their agreement to comply in the future, because that's actually our number one goal in this, is to get them to comply in the future. After we get their agreement to comply, then we'll discuss, any back wages that are due. This is the information on how to contact us. The number that's up there, the 8664 U.S. wage, it's a toll-free number that goes to our national office. If somebody calls that number, and they'll give the basic information to the person answering the phone, and if they make a determination that, yes, it is an issue that's handled by the Wage and Hour Division, typically they'll refer that individual back over, to the appropriate district office. Or if it's something that's handled by another agency, they'll typically make that referral as well. So that concludes what I have to cover with the Wage and Hour Division today. Last, we will hear from Ms. Karen McDonough, the Philadelphia District Office Enforcement Manager for the United States Equal Employment Opportunity Commission, also known as EEOC, on the employment discrimination laws that EEOC enforces, how to file a charge with the EEOC, and the timeframes for filing a charge.
All right. Thanks, James. Good morning, everyone. How are you? As James just highlighted, I'm going to be talking about the laws enforced by the EEOC. I can tell you right off from the get-go here that we only have 6 to talk about, unlike OSHA that mentioned 23, and I'm not sure, I didn't get the totals on wage and hour, but it's way more than EEOC has. But I can tell you that the ones that we do enforce, which I'll talk about in a minute, are very important and can be complex and very and helpful, I'm sure you're going to find in a second. We basically, our laws cover private employers, state and local governments, as well as unions. The laws that I'm going to speak about today are Title VII of the Civil Rights Act of 1964, otherwise known as Title VII, and specific with, I guess, with respect to what I'm going to talk about, it's mainly going to be employment discrimination. And Title VII is prohibiting employment discrimination because of your race, your color, your sex, your national origin. Reprisal, we've heard that from all the other agencies today. Reprisal for filing a charge or participating in any kind of EEOC proceeding. And also prohibiting harassment, and I'll talk a little bit about that. Harassment pertains to all the statutes that are mentioned there, but with respect to Title VII, again, it's your race, color, religion, sex, and national origin. The Age Discrimination in Employment Act of 1967 covers those that are 40 and over. That's the protected age group. And we just want to make sure individuals within that age group, are not being treated less favorably than other employees. So I'll talk a little bit about that in a moment. The Equal Pay Act, it basically protects employees with respect to gender differences in wages. So something like you were talking about, James, with respect to wage and hours, but It prohibits discrimination in the payment of wages to men or women performing substantially equal work under similar working conditions in the same establishment. So a little different. What else we have here? The ADA, you can't discriminate against anyone with respect to their disability. We've heard the OSHA regulations already today mentioned with respect to accommodation issues. And there's a little overlap there, but it's going to be different, and I'll talk about that in a moment. But underneath our law, and this is different across many federal agencies, a person is disabled if they have a physical or a mental impairment that substantially limits one or more of the major life activities of an individual. And this definition has changed. It has, within the last 10 years. Also covers individuals who have a record of such an impairment, and that's important, and also those being regarded as having the impairment, even if they don't. So the Disabilities Act of 1990, kind of pertains to that and covers those individuals. GINA, or the Genetic Information Non-Discrimination Act of 2009, is a fairly new law that we enforced the Commission. So that's really getting into genetic tests that are out there and using any of that genetic information. You fill out a form. Maybe you're hired at a company where they're self-insured. Does the employer get a hold of that information? Perhaps there's a background test that's being done, and it's not just, your criminal activity, but they want to do a full drug scan and find out all of the medications you're on, and that information can lead to learning things about that individual and the background history as well as their family. So GINA prohibits the use of genetic information to discriminate against individuals in employment. There's no exceptions to it. It restricts the deliberate acquisition of genetic information by employers and other entities. It requires that covered entities keep genetic information confidential. They can't mix, they have to have separate medical files from personnel files. We'll make sure we look at that and try to make sure that practice is ongoing. And it prohibits, again, retaliation, reprisal. And we've kind of talked about this even with the whistleblowing and with respect to wage and hour as well. And the Rehabilitation Act is just kind of an act that's absorbed into the other ones, and I'll talk a little bit about that. The next slide, thanks. Laws enforced by EEOC protect you from unfair treatment, and we've heard about that throughout today. Disparate treatment, harassment, and like I said, I went over those statutes, and it could be anything from the race, the color, the religion, the sex, the national origin, age, disability, genetic information. It has to be one of those protected characteristics, or else we won't be able to cover you. So you have to fall underneath one of those statutes. Denial of a reasonable accommodation workplace, I already touched on that, and that could be not only because of disability, but also because of religious beliefs that you have. And retaliation, again, I talked about that, because you complain about job discrimination or assisted with the job discrimination investigation or even a lawsuit. Discrimination can occur in many different scenarios. It can occur at the hiring, the promotion stage, the discharge stage, wages. I just mentioned the Equal Pay Act. When you get demoted, harassment, different terms and conditions. Are they treating you different from someone else who's performing the same job functions? Job assignments, benefits, leave, training, and again, we had heard the training with OSHA early as well, and a failure to accommodate. I already mentioned these. Who is protected from discrimination? An employee, and I kind of mentioned that we cover, private employers, state and local governments, and unions. So an employee who works for any of those three would be covered. It could be a temporary employee, it can be a job applicant, and it could also be a former employee. Also an important, James had mentioned, and Bessie as well, these vulnerable workers, and we also cover undocumented workers as well. So, and I'll talk about that in a moment, because that's one of the Commission's priorities under its strategic enforcement plan, is to make sure that we're looking at these types of cases and the impact on marginalized and vulnerable workers. Okay. Employers covered underneath these laws, Title VII would be you have to have 15 employees. For the Age Discrimination and Employment Act, it's 20. And most employers are covered by the Equal Pay Act, which makes it, again, illegally to pay different wages to men and women if they perform substantially equal work in the same workplace. There are state and local, I just want to say this, there are state and local anti-discrimination laws, which may actually cover smaller number of employees, and I'll touch base on that in a second. And if you go to www.eeoc.gov, it has all that information and all the links to the state laws as well for coverage. We do have strict time deadlines, as both of the other agencies had mentioned as well, to file charges with the EEOC. So you have to file within 180 days from the date of the alleged violation. Again, it's similar to OSHA with respect to the date that you were put on notice. And this can be extended to 300 if your state has what they call a fair employment agency there. They're called FEPAs, and what is that? They're agencies with the state or the city, and we have a relationship, a work-sharing agreement with them. And that 180 days, if there are state laws or city laws, will be extended to 300 as long as you have those fair employment agencies. You may be in a state that doesn't have them, so you have to kind of work within the time frame of 180 days until you get, advised otherwise. And our website has that information on it. You can go directly to court underneath the Equal Pay Act. A lot of times, charges are filed underneath Title VII for gender discrimination, as well as the Equal Pay Act. And in order to file in court under Title VII, you have to come through our agency first. So we're very mindful that you only have 2 years underneath the Equal Pay Act to file in court. So when those cases come in, we do try to track them to make sure that we get them pushed through so that, if you want to file underneath Title VII and the Equal Pay Act, that you're not going to be untimely with that with respect to filing in court. Okay. Again, there's different deadlines for state and local laws, and please consult our website for those as well. How to file a charge? You can come in person to the EEOC, to the district offices, to the local offices. If you look at our website, it has a complete listing of all of our offices. We will take your charge in person. You can also send it in. You can complete it online. You can send it into the address that's listed on our website, or you can actually print it out and take it into our office. We do take charges. Each office is a little different. Some offices have appointments. Other ones, it's kind of walk in, and we take as many as we can during the day. So you have to check the website of the office, and it will have that specific information with what the hours are for taking a charge. Okay. Information for how to do it by mail or fax is online. You just have to make sure your name, your address, your telephone number is on what they call an intake questionnaire. And like I said, that intake questionnaire can be printed online as well. And if you indicate that you want to file a charge, we will automatically document that. If you indicate that and it's signed and you have the allegations on that questionnaire, and we will inform the employer within 10 days that you've come to the commission to file a charge. You can also check off that you just want counseling, and then we don't inform the employer. We wait until we speak with you and counsel you before going forward with the charge of discrimination. Some of the things on the intake questionnaire are, again, a short description of the events you believe were discriminatory. I kind of mentioned these earlier. Were you fired? Were you demoted? Weren't you promoted? Were you harassed? When the actions took place is important because it could be 180 days from that date or 300 depending on your state, and why you believe you were discriminated against. Most important, we had a lot of kickback for people who don't sign them. So it's one of the things that we just tell people to be mindful of. We don't protect federal employees. There is another system for applications for federal jobs and protections, and that's not part of what our agency enforces. However, we do have a hearings unit within the EEOC that, after the individual has exhausted the complaint procedures in the federal sector through their agency, then it can be appealed up to our EEO judges that we have in our office. They fall underneath the directors, but it's a separate system that I'm not really speaking of today. But there's information. If you are a federal employee, there is information about that complaint process online. EEOC investigation. So again, I talked about the copy of the employer being put on notice. A charge is sent to the employer. We do have a mediation program in-house. Most charges, depending on their assessment, are sent to try to get their dispute resolved. So we have a team of mediators in all of our offices. After mediation, if it's unsuccessful, it gets assigned to an investigator. The investigation, we try to have it done within 8 months or so. We collaborate with other federal agencies, Wage and Hour Division. We have some investigations ongoing with them in a collaborative nature in our district. And also OFCCP, we've also had investigations because they cover federal individuals who are to have federal contractors. So that's pretty much where I'm at. There's all different, aside from, the investigation, real quick, I'll just say that after the investigator is done collecting all the evidence, they issue a letter of determination, and that will either say whether they believe a violation has occurred or hasn't occurred. We conciliate cases, and in some cases move forward with respect to litigation. At all times, individuals can, after 180 days, an individual can request a right to sue and file in court themselves. That's pretty much where I'm concluding today. I've mentioned our website. For more information about filing a charge process, our number's up there, 1-800-669-4000. We're also TTY, and there's our website. And now I'm going to give you back to Bessie Chan, advisor at the White House Initiative for Asian American Pacific Islanders. Bessie.
Thank you. Thank you to our speakers for sharing this very valuable information today. Before we get started with our Q&A, I'd like to ask 2 questions that we received from participants via email. And the first one is, what if a worker has an issue that is relevant to more than one agency?
This is Isabel de Oliveira from OSHA, and I'll just let you know how OSHA would handle it. If the area office received a complaint that had multiple agency issues on it, we would scan, PDF it, and then email it to one of our associate district offices or EEOC offices in the local jurisdictional area. And then they can make their own internal determination of what to do and process it. We would also probably provide a notification letter to the complainant of where we sent the letter.
Great. Thank you, Isabel. And then also, are all complaints and charges investigated?
Hi, this is Jim Kane from the Wage and Hour Division. For us, unfortunately, the answer is no. We don't investigate all complaints. First of all, we'll go through a screening process to determine whether or not we have what we consider a valid complaint, and that means that there's a high likelihood that there is a violation of one of the laws that we enforce. But even so, we receive so many complaints, throughout the course of the year. And unfortunately, we have a limited number of, resources and investigators to actually conduct the investigations. So we actually go through a process of determining, even if we think that there's a violation, whether or not we'll actually go out and conduct an investigation. One of the things that we do, if we decide that we're not able to actually conduct the investigation, is certainly we would notify, the individual that we're not going to take any further action. But typically what we also do is notify them of any independent rights that they have, which they do under, most of the laws that we enforce. They have private rights of action where basically it allows them to get an attorney and pursue it on their own behalf.
Okay, thank you. Could we please have the operator jump on to start the Q&A?
Thank you. We will now begin the question and answer session. If you would like to ask a question, please press star 1. Please unmute your phone and record your name clearly and slowly when prompted. Your name is required to introduce your question. To withdraw your request, press star 2. One moment, please, for the first question. At this time, speakers, there are no question in queue.
Okay, well, if anyone has any questions, definitely feel free to email us after this webinar. You can contact us at whitehousEAPI@ed.gov. That's whitehousEAPI@ed.gov. And I just want to thank you again to all our speakers and participants for joining today's webinar. We'll be sending out the presentation via email shortly, and a recording of the webinar will also be posted to our YouTube page at youtube.com/WhiteHouseAAPI in the upcoming weeks. And lastly, just please take the time to complete our webinar evaluation survey. It's going to be sent out to you via email because we would love to hear your feedback to ensure that we can improve future events and webinars. Thank you.
That concludes today's conference. Thank you for participating. You may now disconnect.